And we're back. This is the Law and Crime Network. I'm Michel Bryant with my guest along for the afternoon to cover the case out of South Carolina against Timothy Jones Jr. They are still in a break. And just to give you an update on other stuff that's going on, because you know we've always got a few balls in the air here. The case against Charles Merritt out in California, the jury got the case yesterday. Yes, pinch yourself. It actually happened. The jury has the case. They deliberated a few hours. They'll be back at it Monday because it is Friday, which means it's a Merritt holiday. The other case we've been covering, of course, is Kellen Winslow II. They had some housekeeping to take care of in court today with the jury absent, so the jury is not working on the case today. All 5 alleged victims, Jane Does 1 through 5, have testified, so that case will pick up again on Monday. It's moving very quickly. They had estimated 3 to 4 weeks. It's going to be done long before that, so we should be wrapping that thing up early next week, by maybe midweek at the latest. Anyway, so it's giving us a chance now with the break in the South Carolina courtroom to catch up on some of the defense expert testimony. It's been a bunch. Remember, it's their burden, as Tara pointed out, it's their burden to prove their guy was insane at the time of the killings. Remember, too, the burden of proof is just preponderance of the evidence. More likely than not. You know, when I get a hamburger, am I more likely than not to get fries? You know, probably going to get the fries. So it's a very tight burden there. It's not overwhelming. And these experts are key to making that happen if this defendant is going to avail himself of that defense. So, very interesting yesterday was a head shrinker, that's my fond name for the psychiatrists and mental health professionals, and I say that with respect. He had an interesting set of opinions. Now remember, the goal here is to prove that the defendant didn't understand that he was doing something morally or legally wrong. Didn't understand that. That's the crux of the defense. Listen to this defense expert, okay? This is Dr. Frierson. He testified yesterday morning. Listen carefully. I had to listen 2 or 3 times to make sure I heard what I heard. Listen. What is going on here? This is the defense expert being examined on direct by defense counsel. Gabriel Sepulveda Sanchez with me here, trial attorney out of L.A. Was it a mistake? Was it, did he forget who paid him? Why would this defense expert say that the defendant did understand and recognize moral and illegal or legal right from wrong at the time of the murders?
Was that a defense expert? I thought that was a DA expert. Was that a defense expert? I don't know. We
lost the audio there. Tara, let me ask you the same question. What did I miss? There's some secret formula that I can't quite get?
Yeah, you know, I have to say, when I was reading the article recapping his testimony, I thought this may have been either a court-appointed psychiatrist or a witness for the state. But now that I'm hearing it's a defense witness, I'm shocked, particularly because any opinion that he gave on the stand would have obviously been provided to defense counsel ahead of time. So they must have anticipated that he was going to testify to the fact that he concluded that this particular defendant could tell legally and morally right from wrong on the days of the alleged incident. So, you know, that certainly does not help their case. I mean, there may be some testimony that may be helpful to them in mitigation with regard to his ultimate diagnosis that he was suffering from some substance abuse psychosis. But that opinion and that conclusion certainly does not support an insanity defense.
Gabriel, I think we have Gabriel back now. You know, if I'm the prosecution, I'm going to say, hey, we agree 100% with this defense expert.
I was just totally confused. I mean, the way the expert was testifying was as if he was the prosecutor's expert. That's why I was baffled right now. I mean, no, that's not good at all. He's basically saying that he knew what he was doing. He wasn't delusional. He was paranoid. So I don't. If that's a defense expert, then that's an error. They shouldn't have not. I would not let that guy be. I wouldn't use him as an expert.
Yeah,
that sounds to me like a DA expert.
I think Aaron Keller said it best. He used one of those Latin terms. He said, "Oopsie." It's almost like an accident happened. Let's go back into the courtroom now. They're back on the stand. There is the doctor. This is redirect of Dr. Dorney. It looks like they're getting some housekeeping issues underway there. Maybe a technical problem. Maybe there's some exhibit of some sort they need to deal with. Tara, let me ask you, just generic expert background information here. You know, when you bring an expert onto a case, generally you don't want to have a report done until you know what they want to say, and then because that report's going to be discoverable. What's your way of handling experts in a dicey situation where you really don't know what they're going to say until they say it?
Well, I think there has to first be, as an attorney, an extensive investigation into the backgrounds of the individual. The reality is when investigating experts, there are experts that are biased towards the state and some that may be biased towards the defense. I know in this case that this was a court-appointed psychiatrist, so the situation in South Carolina is a little different than it is in New Jersey. But typically, that's where the job starts, is finding the appropriate person for the job. And then thereafter, you're in a continuing discussion with that person and having continuing conversations as the facts develop before they're prepared in any report. Because as you said, once it's down in a report, you have an obligation as a defense attorney to provide that to the state if you're going to in fact call that person to testify at a trial.
Hey, it just looks like there was a very, very brief redirect there, no recross, and the doctor looked to me like scurried from the courtroom like she had an appointment she was going to miss. She had a tough day and a long day on the stand there, Gabriel. I think from what you saw, how do you think she did? Did she do her job?
I liked her. She did her job. She answered some tough questions. It makes sense now with the court-appointed expert. I remember I had a case when I did more criminal law. And my first experience as a court-appointed expert, first of all, they build a state. So they're kind of working on their own time. They kind of do what they want to do. You're not paying their bill, the state is. And nothing personally towards state court-appointed experts. I don't like using them.
Nothing wrong with them.
Yeah,
yeah.
That
Okay.
situation you just seen, that almost happened to me in one of my cases, and luckily we negotiated a plea deal before a trial. But yeah, I like the way she was handling her questions. You can tell she was, more prepared, I felt like. And she basically was saying, at the time of the action, he didn't know the nature of his act. He didn't know at the time of the crime was committed. He didn't know the wrongfulness of his actions. And she answered all the questions the way I would want her to answer.
Yeah, she definitely had the opinion that she needed to have. And the real question is whether the jury is buying it or whether the prosecution was able to poke some holes in that. You can see now the judge is giving some instruction to the jury. That is because the state has rested in South Carolina versus Timothy Jones Jr. Let's see. I'm sorry, the defense is rested. Yeah, so now we'll see if there's a rebuttal case. Seems to me with the judge, can we tell what this judge is saying? Can we dip in there and see what he's up to? Foster, the daughter of Jane Doe number 1. Remember, Jane Doe number 1 is connected to the events allegedly taking place on March 17th, 2018, and the counts against the defendant relating to this Jane Doe is kidnapping, forcible rape, and forcible oral copulation. Those are 3 of the charges of the total 12 charges against Kellen Winslow II. So you might be asking yourself, hey, how come this witness is being able to testify and just basically repeat what her mom said? Well, in California, an odd kind of evidentiary rule about being able to repeat prior consistent statements to buttress the prior testimony already given by her mom. That's why she's there. Gabriel Sepulveda-Sanchez is with me, trial attorney from Los Angeles. What do you think about, you've seen all of the Jane Does. How did you like Jane Doe 1, and what do you think she impressed upon the jury?
Jane Doe 1, if I can remember, because there's like 5 in them. I think Jane Doe 1 was the one that kind of came out with testimony she kind of had inconsistent statements. I didn't like her very much.
Yeah, she wasn't very likable. Let me ask you, Tara, what did you think about her and her importance to the whole case? Quickly, we got to take a break here.
Unfortunately, I wasn't able to view her testimony live. So I really couldn't give an opinion on that. I did read that she had some credibility issues. There was some testimony that she didn't take opportunities to either alert authorities or escape when she could have. So, those types of issues that come out on cross-examination certainly would help the defense in this case, and I don't think, are particularly helpful.
Yeah, I believe, really, my thought all along has been that this case was won by the prosecution when they beat back the severance motion by the defendants. So we'll see how that plays out, because all these cases together add up to problems for Mr. Winslow. We'll be back with more on the Law and Crime Network in just a few moments. Stay right where you are.